The Insatiable Thirst to Ban Guns. From The Gun Rights War by Neil Knox. This is page 118. It's dated July 29th, 1988. There is a silly notion, fervently adhered to by many gun owners, that if our side of the gun issue would just sit down and talk with the other side, we could work out a reasonable compromise that would satisfy society's need to keep guns out of the hands of criminals while imposing little inconvenience upon law-abiding gun owners. And then the lion shall lie down with the lamb. If all the evidences of the past have not convinced the utopians that the other side will never be satisfied with a reasonable compromise, perhaps the present situation will. A ban on the manufacture and sale of plastic handguns, essentially guns with less than 3.7 ounces of steel, has passed both houses and is awaiting either a negotiated agreement or a conference committee to resolve differences before being signed into law. Not satisfied, the anti-gunners have attached a 7-day waiting period with police notification of the transfer, including a description of both the buyer and the gun, to the fast-track must-pass anti-drug bill, H.R. 4916. The bill, already approved by the full House Judiciary Committee, may have been voted upon in the full House by the time you read this. Not satisfied, the House Judiciary Subcommittee scheduled hearings on H.R. 3978 by a representative from Florida that would give the BATF authority to ban all handguns, not particularly suitable for sporting purposes. Not satisfied, the lead paragraph of page 1 Washington Post story says that a Manassas, Virginia police officer was gunned down with a semi-automatic rifle that can be purchased without questions at any Virginia store. When will they be satisfied? From the thrust of their arguments, what they have said and advocated in the past, and from the occasional glimpses at their hatred of powerful rifles capable of long-range death and quick-firing lethal shotguns, no reasonable man can conclude that the anti-gunners will be satisfied with anything less than a gunless society when only criminals will have guns. Without exception, every time a gun law is enacted, usually with the help or acquiescence of gun owners and their organizations, the advocates are soon back demanding yet another reasonable step that will work where their previous efforts have failed. That isn't paranoia, it's historical fact. In England, so often held up as their model for gun control, all semi-automatic and pump rifles and shotguns have just been placed in the same almost totally prohibited class as handguns. The initial plan, announced last winter, called for the guns to be confiscated without compensation. But that was knocked down by determined opposition of the gun owners who mounted an unprecedented lobbying effort. According to a recent letter from the British Home Office, the government, to an Arizona friend, Lee Knopener, there are relatively few sporting purposes for which a conventional shotgun will not serve just as well as a pump or self-loading one. For those who want to hold such weapons will have to satisfy the police that they have good reason for doing so. Most folks have enough trouble satisfying their wives that they need another gun. How would you like to have to satisfy the cops that you need each gun in your battery? The most galling line in that 3-page letter is the legitimate activities of shooter are to be protected for many years to come against more harsh measures than a new package of gun controls is necessary. Isn't that nice? They only enacted these draconian new prohibitions to help the gun owners to prevent something far worse from being enacted. Sound familiar? Every U.S. gun law, without exception, has been enacted with the active support or quiet agreement of the NRA, each time to prevent something worse from happening. Every time the NRA stood in total opposition to a proposed gun law, we prevailed, even when the defeat seemed inevitable. As it did when the fledgling NRA Institute faced H.R. 11193 in 1976, a so-called Saturday night special ban that would have wiped out about 2/3 of handguns, or when we shot down BATF's 178.31, 178.131, a gun registration regulations in 1978. These fights appeared unwinnable, but winning them not only stopped the other side, they made it possible for NRA-ILA to go on the offensive in 1979 with the McClure-Volkner bill, which would have gutted the Gun Control Act of 1968. But in 1983, NRA-ILA, under different leadership, became more reasonable, accepting a dozen gun-gutting amendments to McClure-Volkner. The law passed in '86 with a total ban on new machine guns, which had been tightly regulated for 50 years and had never been a crime problem. Also, in 1986, solid bullets, so-called cop killer bullets, for all handgun ammo and some rifle ammo were also banned. Incredibly, the Democratic Party platform passed in Atlanta demands the prohibition of those already prohibited bullets. Instead of satisfying the anti-gunners, these wins, the machine gun ban, AP bullets, and even the essentially gutted plastic gun ban, merely whetted their appetite. Now they're going full board for a national waiting period that will be difficult to stop. As baseball catcher Yogi Berra said, it's deja vu all over again as we again face House hearings on a Saturday night special ban. A battle that was won a dozen years ago, but is now resurrected in both Maryland and the Congress. At minimum, it means a major push to ban non-sporting handguns in the next Congress, and it probably means a floor amendment to the waiting period provisions this year. If we fail to win the Maryland referendum, challenging the state's new law banning all handguns not specifically approved, which will be on the November ballot, we're going to have our work cut out for us in Congress and in many other states. Further, states from coast to coast are flirting with laws to ban some or all semi-auto rifles and some semi-auto handguns. And that thrust is already showing up in the editorialized news stories and editorial cartoons of the Washington Post and other major newspapers. Clearly, semi-auto rifles, not just AR-15s, but guns like my Remington 742, are next on the list. Yet, with all these signs of whetted anti-gun appetites and more restrictive legislation waiting in the wings, some of my friends and fellow gun owners are telling me that we shouldn't oppose such reasonable provisions as waiting periods, background checks, and that a reasonable law will put the gun law issue to rest. I know these folks aren't stupid, and I don't really believe they're simply tired of fighting. Most of them never worked up a good sweat in the gun law fight. Many are just embarrassed because they haven't actively participated in the fight or even contributed to the NRA Institute or Gun Owners America or Second Amendment Foundation or my fledgling Firearms Coalition. Maybe it salves their conscience to say that all these gun groups are too radical, but noticing that they're adapting the theme of Handgun Control Inc.'s advertising. Maybe they are motivated by a desire to be perceived as more respectable and hopeful that a more positive outlook towards reasonable gun laws will exclude them from the virulent anti-gun owner editorials and vicious cartoons. Whatever these gun-owning friends' motivation, I think that if they think that the waiting period police notification bill now before Congress is a modest compromise, one that will slate the thirst of the anti-gunners, they're mistaken. Then there's a note by his son, Chris. The single exception to the history of NRA either supporting or acquiescing to the federal gun law now on the books is the 1994 Clinton assault weapons ban. Bill Clinton signed that bill half a decade after this piece was originally written. ILA, under the leadership of hardliners, fought the Clinton bill with everything it had and lost. The tactical loss turned into a strategic victory. The long-term result was that the Democrats losing its lock on the House majority and for the first sitting speaker to be turned out of office in a century. Because of the tough fight, the other side had thrown a 10-year sunset provision into law as a sweetener. No one in Washington, Neil Knox included, seriously expected the sunset to be exercised, but opposition to the ban bubbled up from the grassroots, and by the time 2004 rolled around, Congress, having learned from previous experience, looked the other way as the sunset provision kicked in. This next one's long, so I'm going to go to the next one. Thank you for supporting our projects. If you'd like to buy us a cup of coffee, check out our Patreon channel.
The guys and gals at gunwebsites.com encourage you to take a CCW class every year, practice at least once a month, and carry every day. Thank you for watching gunwebsites.com.